No, Your Honor, I was mistaken. That was how she tried to do it, quietly, cleanly, as if the truth could be folded up and put back in her purse. 3 days earlier, under oath, she had named the defendant without hesitation. She had signed the statement, initialed each page, confirmed it once before counsel and once again before the clerk. Then she stepped into my courtroom, raised her right hand, looked at the ceiling for 1 second too long, and tried to bury the whole thing in 6 words. I did not look at the lawyers first. I looked at her hands. They were flat on the rail, but not steady. The fingertips kept lifting and touching down, like she was counting seconds that only she could hear. Then I followed her eyes. Not to the defendant, not to the prosecutor. Past them, 3rd row, end seat, a man I had not seen earlier, though that did not mean he had not been there. Dark coat buttoned high, one ankle over the other, face blank, too blank. He was watching her the way some men watch an open safe. Defense counsel was on his feet before I said a word. Your Honor, if the witness is recanting prior inconsistent statements, I would ask that the court instruct the jury accordingly and allow me to proceed. He said it fast, faster than he had spoken all morning. He wanted momentum. He wanted her retreat to become a record before her courage returned. I leaned back and said, "Sit down." Not loudly. I never had to be loud when I meant it. He sat. I turned back to the witness. "A moment ago you said you were mistaken. I'm going to ask you again, and this time you will look at me when you answer. Were you mistaken then, or are you lying now?" The prosecutor shifted. Defense counsel half rose again. The man in the 3rd row moved one finger across his lips, small as a twitch, the kind of movement most rooms miss. I did not miss it. "Bailiff," I said, still looking at the witness, "close the back doors." You could hear the hinges before anyone understood why I had ordered it. The witness swallowed hard. Her mouth opened, closed, opened again. "Your Honor, She stopped. Defense counsel stood. "I object to this line." "You object too often," I said. "Sit down again." He sat harder that time. I let the silence do some work. People rush silence because they fear what arrives in it. I had been on the bench long enough to know silence is where pressure stops being theatrical and becomes truth. "Ma'am," I said, "is there a reason you cannot answer me?" She looked at me, then past me, then down at the rail. Her shoulders drew in so tight, it looked like she was trying to make herself disappear without leaving the stand. "No." "Then answer." Another pause, longer. The prosecutor took a step toward the lectern, then thought better of it. Defense counsel uncapped his pen and recapped it without writing a thing. The man in the gallery uncrossed his ankle and leaned forward 1 inch. That 1 inch told me more than an affidavit. The witness whispered, "I was mistaken. I picked up the statement from my bench. I did not waive it. Paper has no authority unless the court gives it some." "In this sworn statement," I said, "you said you saw Mr. Kessler leave the municipal records office at 9:14 p.m. carrying a red ledger. You said you heard him tell Inspector Vale to burn the copies and lose the seal log. You said that after the fire in the Crescent building, the official file was not the official file. Did you say those things?" Her lips trembled once. She nodded. "Say it." "Yes." "And now you say you were mistaken." "Yes." "About all of it?" She did not answer. I let the question hang there long enough for everyone to feel how much weight was in the word all. That was when the man in the 3rd row rose halfway, like he meant to stretch, and said, "She answered." He did not shout. He did not need to. He said it with the confidence of someone used to rooms bending around him. Every head turned toward him except mine. I kept my eyes on the witness. "Bailiff," I said, "if that man speaks again without permission, remove him." Then I said to her, "Who warned you?" The courtroom changed shape. You could hear it in the breath that passed through the gallery. You could see it in the prosecutor's face, which went from confusion to calculation in a single beat. Defense counsel stood so fast, his chair rolled backward. "Your Honor, this is outrageous. If there is an allegation of witness intimidation, then the proper remedy is a hearing outside the presence of the jury." "Counsel," I said, "you are very concerned with where the truth is allowed to appear." He stopped moving. The witness gripped the rail so hard, her knuckles blanched. She did not cry at first. People imagine breakdowns arrive with tears. Often they begin with stillness. A person becomes so still you can see the fight happening underneath the skin. I asked again, "Who warned you?" She shook her head once. "Did someone threaten you?" "Nothing." "Did someone threaten your family?" Her breath hitched. The man in the 3rd row turned toward the side aisle. Stop him, I said. Now the room broke. The bailiff moved. The man moved faster. Defense counsel objected over the top of both of them. The prosecutor was asking for a recess. Someone in the gallery stood up, then sat back down when the second bailiff stepped in. The witness flinched at the sound of shoes scraping wood and covered her mouth with both hands. I struck the gavel once. That sound matters. People think it is ceremony. It is not. A courtroom is a place where chaos is always one weak voice away. Wood brings it back. No one leaves, I said. The man froze near the aisle. He did not look afraid. He looked irritated, which in some cases is worse. Then the witness said it. They warned me. Not loud. Not polished. It came out broken in the middle, like the sentence had been forced through a locked door. I did not move. I did not rescue the moment with more words than it deserved. Who is they? I asked. She looked directly at the man near the aisle. He looked back at her, and for the first time his face changed. Not much, just enough. One look, one warning renewed in public. The prosecutor saw it. I saw it. The jury saw it. Defense counsel moved to block the line of sight. Your Honor, I demand that the gallery be cleared and the jury instructed to disregard. Demand something in your own office, I said. In here you request. I turned to the witness. Are you pointing to that man? Her shoulders began to shake. She lowered her hands. One of her nails had snapped to the quick. I noticed because she kept rubbing the torn edge against the wood, as though pain in one finger might keep the rest of her from speaking. He came to my house, she said. The man in the aisle said, That's a lie. The bailiff took his arm. He jerked free. And now we had it. Not just fear, but resistance in the open. If it is a lie, I said, you will have every lawful opportunity to say so after you are identified. Until then, you will remain exactly where you are. He stared at me. Men like that always try the same calculation. They look at the robe. They look at the room. They measure whether the bench is decoration or force. I held his gaze until he lowered his eyes first. That bought me 10 seconds. 10 seconds was enough. Ma'am, I said, tell me what he said. Defense counsel was up again. Your Honor, she is hysterical. I slammed my palm flat on the bench, not hard, just final. One more word from you while this witness is answering, and I will hear the rest of your arguments after a contempt advisement. He sat. The witness licked her lips and said, He said my son gets out of school at 3:15. He said traffic gets bad on Mercer after 3. He said kids disappear in traffic every day. Nobody moved. Sometimes silence is not empty. Sometimes it is a room realizing it has been living next door to evil and calling it business. The defendant, Mr. Kessler, had sat comfortably through every hearing until then. Good suit, better watch. The posture of a man who believes systems were built to absorb his mistakes. When the witness spoke those words, he turned his head very slightly toward his attorney. Not toward her, not toward me, toward his attorney. That little turn told me where his concern lived. Not innocence, containment. If you're watching me now, understand this. The law is never tested when decent people cooperate. It is tested when fear enters under oath and power expects the room to kneel. I ordered the jury out. Defense objected. The prosecutor wanted an immediate protective order. The man from the gallery finally gave his name, too quickly for me to trust it. Leonard Dane, he said. Said he was a cousin, said he had every right to attend public proceedings, said he had never seen the witness before in his life. He said all of that before I had asked more than 2 questions. That is another thing experience teaches you. Innocent people answer what was asked. Guilty people race to answer what is coming. I had the bailiff keep him in the courtroom while the jury was escorted out. Defense counsel argued prejudice, mistrial, prosecutorial misconduct, judicial overreach. He threw words at the walls like a man trying to start enough fires that nobody notices which one matters. I let him spend himself. Then I asked the witness one narrow question. Did you tell anyone, besides law enforcement and the prosecutor, that you were coming here today to testify? She shook her head. The prosecutor said, Your Honor, the witness has been housed at an undisclosed location since last night. I turned to him slowly. Who knew that location? He hesitated. That hesitation did more damage than any confession. Answer me, I said. My office, investigating detectives, victim services. And defense? No, Your Honor. The witness made a sound then, not a word, more like someone catching herself from falling. She looked at the prosecutor, not with outrage, not with accusation, but with the dead look of a person who has just learned the walls leak. That mattered, because up to that moment, this was intimidation. Ugly, serious, prosecutable, but still narrow, still local, still one frightened witness, and one arrogant man in my gallery. Then she said, He knew the motel room number. No one breathed. The prosecutor went pale. Defense counsel looked furious, but not surprised enough for my liking. And Mr. Kessler, seated at counsel table, lowered his eyes to a yellow legal pad he had not written on once all morning. That was the moment the case stopped being about a fire in the Crescent building and became about who had been moving inside it with keys. You deserve the context now, because by then the room had earned it. The Crescent building was supposed to be empty the night it burned. Old apartments on the upper floors, street-level offices below. The city had flagged the property for violations for months. Blocked exits, exposed wiring, altered records. Then somehow, the violation file went thin. Pages missing, sign-offs appearing after hours, inspection notes rewritten. 2 weeks later, a fire started on the second floor, spread through the central stairwell, and trapped a night janitor named Luis Mercado inside. The state charged Daniel Kessler, the building's managing partner, not because suspicion is enough, but because records placed him in the municipal archives before the fire, and witnesses put him in a car outside the building afterward. The state's theory was simple on paper and rotten underneath. The building had become a liability, records had become a threat, and someone chose flames over exposure. Simple theories make juries comfortable. Real cases rarely stay simple. The witness on my stand, Elena Voss, worked as a file clerk in the records office. She was nobody powerful, nobody connected. The sort of person predators count on because they think ordinary lives are easy to frighten. She had first told investigators she saw Kessler and City Inspector Martin Vale leave the archives with a red ledger and a seal press 2 nights before the fire. Then she identified pages in the rebuilt file that had not come from the archives she managed. She knew because she stamped the originals herself. That morning, I had expected a hard-fought evidentiary day. I had not expected organized fear to walk into my courtroom and sit where I could see it. And if you've ever wondered whether a courtroom can still matter when powerful people start leaning on the weak, stay with me. What happened next is exactly why I never confused procedure with justice. I cleared the public gallery, except for credentialed press, and ordered deputies at both doors. I put Elena in the witness room with a female officer and directed that no attorney, not even the prosecutor, speak to her without leave of court. That displeased everyone equally, which is often a good sign a judge is finally standing in the right place. Then I turned to Leonard Dane. Your identification. He handed over a license. I looked at it once and passed it to the bailiff. Run it. Defense counsel sprang up. On what basis are we detaining a member of the public? On the basis, I said, that he inserted himself into witness testimony, attempted to leave after a direct question regarding intimidation, and is now the subject of an on-the-record allegation that includes a threatened child. He opened his mouth again. I raised one finger. He closed it. That should have settled the room. It did not, because villains do not surrender simply because a judge notices them. They adjust. The prosecutor approached and asked for a sidebar. I granted it. He came in too close, voice low, and asked that we suspend testimony for the day. Said his office needed time to evaluate witness security. Said proceeding might compromise future charges. Future charges for whom? I asked. He looked at the table where Kessler sat, then toward the door where Dane was held. Then he said the most dangerous thing a frightened official can say. We don't know yet. I said, that is not what worries me. He did not answer. What worries me, I said, is that a protected witness says the man who threatened her knew the motel room number. Rooms do not leak numbers by magic. He asked for patience. I told him to earn it. When we went back on the record, the bailiff returned with the first crack in the wall. The license Leonard Dane had produced belonged to a man 6 years dead. Now we had fraud inside a courthouse, during testimony, in the middle of a witness tampering allegation. Defense counsel tried to downplay it, said fake identification proved nothing about his client, said the court was conflating separate events, said the jury had already been exposed to incurable prejudice, and demanded mistrial again. I looked at Mr. Kessler. He had finally started writing on his yellow pad. Not notes, little boxes, same shape over and over. A man building somewhere to hide in his own head. No mistrial, I said. He stood. I did not let him speak. Not today. Not on intimidation. Not while the source of that intimidation is still emerging. This court will not reward interference by collapsing the proceeding the moment interference succeeds. That line landed because it was true. You cannot let power discover the button that stops justice and then act surprised when it presses it again. We brought Elena back in without the jury. I told her she was under protection of the court and that nobody in that room would approach her child that day without meeting deputies first. I did not tell her not to be afraid. Judges waste words when we start telling people what fear should do. I told her what I could do. Then I asked, "Did the man who threatened you act alone?" She stared at the microphone for several seconds. "I don't know." "That is not the same as no." "No." "Did he mention a name?" She nodded. Defense counsel was up. Privilege, hearsay, foundation. "Sit down," I said, and he did not even argue this time. She said, "He told me to remember who signs inspections in this city." Nobody needed help understanding the name attached to that sentence. Martin Vale. The inspector whose initials appeared on the last cleared report for the Crescent building. The inspector who had denied ever meeting Kessler outside official channels. The inspector whose schedule, according to the exhibits already admitted, placed him homesick the night Elena said she saw him in the archives. You see the shape now. A witness changes her story. A man appears in the gallery. A protected motel room leaks. A threat mentions school traffic and inspection signatures. By then, this was no longer a case trying to survive. It was a case trying to tell us how many hands had been around its throat. And right there, before the next turn, let me say this. If you believe the powerful only get bold in alleyways and back rooms, you have not watched them long enough. The confident ones walk straight into court and test whether anyone in the robe still deserves it. I ordered Inspector Vale produced the next morning under subpoena. The prosecutor objected to the timing. Too bad. He could object on paper after we finished saving his case from whatever had infected it. But the next attack came before morning. At 4:22 p.m., after we had recessed, my clerk brought me an emergency filing. Defense sought immediate release of Kessler's financial records that had been sealed pending authentication. That filing had been drafted hours before the witness broke down, which meant while the courtroom was exploding, someone on that side was still moving papers with machine precision. Control. Always control. Keep pressure on every flank. Give the other side too many fires. I denied it from chambers. Then I learned Elena's son had not arrived at the secure pickup point arranged by deputies. That is the line. That is the moment when procedure becomes a race. The deputy on the phone told me the school had released him to an authorized municipal escort. No name provided. Badge flashed. Sign out rushed. I was back in the courtroom hallway before the call had finished. The prosecutor came running from the stairwell. Defense counsel appeared from nowhere, asking what was happening. I did not answer him. I called the school principal myself and asked one question. Did the escort sign the log? Yes, Judge. Read me the name. A pause. Paper rustling. Inspector Vale. The prosecutor swore under his breath. I did not. Anger is cheaper than control, and cheaper things rarely hold. Lock the school, I told her. No one else enters or leaves until deputies arrive. Check every camera you have from dismissal to now. Call the office where the child was supposed to be delivered. He may already have been returned if the bluff failed. A bluff. That was my first hope. Threats often aim at imagination first. If they can force panic without taking the final criminal step, cowards prefer it. 30 seconds later, we got the second call. Elena's son had been found in the front office bathroom, door locked from the outside, crying but unharmed. Someone had walked him in through a side entrance and left. Not mercy, theater. Enough to prove reach, enough to tell the mother, next time we won't just borrow him. I went back on the record at 5:03 p.m. because some days the only safe place for truth is under transcription. I recited every known fact in open court. The false identification, the threat described on the stand, the motel room number leak, the fraudulent school pickup using Inspector Vale's name. I ordered warrants reviewed that evening for Dane and directed the prosecutor to preserve every courthouse camera angle from the moment doors opened. Defense counsel argued that my remarks would poison the jury pool. Counsel, I said, if the pool is poisoned, it is because someone poured poison into it. That night I did not sleep much. Judges do not chase suspects, we do not kick doors. Our power is narrower. But narrow power, properly used, can still force daylight into places darkness rents by the hour. The next morning Vale appeared in a grey suit and a face that had practiced innocence all night. He denied everything quickly, too quickly, said he had never visited Elena's home, never contacted her, never knew where she was staying, never went near the school, never authorized anyone to use his name. Claimed his office keycard had been stolen weeks earlier, claimed the signature on the school log was not his, claimed the building inspection records were accurate, claimed he could explain every after-hours entry in the archive. I asked him to explain one. He looked to counsel. Counsel nodded. Vale said he had been called in to correct a clerical issue. At 9:14 p.m., I asked. I'd have to check the exact time. You won't, I said. I already did. Then I had the clerk publish the courthouse security footage from the prior day. Not the fire, not the archives, not yet. I delayed the thing everyone wanted, because first, I wanted the lie trapped in something immediate. The screen came alive. Grainy hallway outside courtroom B, timestamp visible. Leonard Dane enters at 8:41 a.m. He does not come alone. 3 steps behind him, cap low, coat collar up, is Martin Vale. Not inside the courtroom, not seated together, but there, arriving together, splitting before the door. Vale's attorney objected to relevance. His voice cracked on the second syllable. I let the footage run. At 8:46, Elena is escorted from witness holding to a side restroom by victim services. At 8:47, Vale appears in the hallway again, stops near the restroom corner, and speaks to someone just out of frame. At 8:48, Leonard Dane walks away from that same corner adjusting his sleeve. No audio. No direct handoff. Nothing dramatic enough for cinema. More dangerous than cinema because it was ordinary, coordinated, practiced. Vale said the footage proved only that he had come to observe a public proceeding. Is that why you concealed your face? I asked. I wasn't concealing anything. Then why did you remove the cap the moment you reached the stairwell camera and put it back on before this hallway? No answer. Mr. Kessler shifted in his chair. He had lost the stillness rich men mistake for invulnerability. Now the prosecutor found his legs. Asked for expanded conspiracy charges, asked for remand, asked for emergency sequestration of all municipal archive logs. Defense objected to everything, which is what defense does when the floor begins to move. I granted some, denied some, reserved others. The law still had to be the law, but I was not done, because there was one more thing that had bothered me from the moment Elena first cracked. She had not simply feared for herself. She had arrived ready to lie completely. That takes reinforcement, repetition, contact, pressure beyond one visit to a house. So I asked the prosecutor for the call records from the witness protection line that had housed her hotel transfer. He said they were being processed. I said, processed faster. By noon, we had them. 3 outgoing calls from a restricted administrative extension inside the district office to a disposable phone recovered from Leonard Dane at booking. 1 call made 22 minutes after Elena checked into the motel. 1 made the morning of testimony. 1 made during the lunch recess the day before. There it was, not a rumor, not a theory. A line from the prosecution's own building to the man who threatened the witness. The room went cold. The prosecutor looked like he had been punched. Defense counsel stopped performing for the first time in 2 days. Kessler closed his eyes. Vale stared at the table. And I understood right there why some conspiracies survive so long. Not because they are brilliant, but because institutions are embarrassed to admit how cheaply they can be entered. We traced the extension to a victim services coordinator named Paula Marin, middle-aged, 20 years in service, no disciplinary history. She was brought in with counsel and testified under immunity that same afternoon. Not because I wanted speed for its own sake, but because delay was the conspirator's oldest friend. She said Kessler never spoke to her directly. Vale did. He told her the witness was unstable, said if Elena disappeared before trial, the city would be embarrassed and Marin would be blamed for mishandling placement. Then he offered to smooth things out if she shared the motel details so he could send reassurance through intermediaries. She did it. Cowardice dressed as practicality. That is how corruption enters ordinary offices. Did you know a child was threatened? I asked. She started crying. I did not ask again. I asked something better. When you gave him that room number, what did you think would happen? She had no answer worth the record. By then, the state had enough to supersede the original indictment. Kessler for arson-related homicide, evidence tampering, conspiracy, and witness intimidation. Vale for conspiracy, witness tampering, official misconduct, and fraud. Dane for intimidation, false personation, and obstruction. Marin lost immunity protection on certain counts, when later evidence showed she had deleted messages after receiving a preservation notice. And Elena, she came back to the stand after all that, 2 days later, with deputies at the door and no man in the third row. I asked her one final time, in front of the jury, were you mistaken then, or were you lying now? She looked straight at me. I was trying to keep my son alive. No lawyer in that room could improve on that sentence, so none of them tried. She testified, clean, precise. Not because fear had vanished, but because fear had finally been met by force greater than itself. The jury convicted, not on outrage, Not on theatrics, on records, footage, calls, lies, entries, signatures, and the simple fact that people who tamper with truth leave fingerprints everywhere once someone stops letting them wipe the glass. I sentenced Kessler months later. He stood where powerful men always stand in the end, smaller than the room they once thought they owned. Vale lost his pension and his license before he lost his freedom. Dane learned that swagger is a poor defense against transcripts. Marin learned that "I didn't think it would go that far" is not a legal doctrine. And Elena walked out of the courthouse with her son and without looking over her shoulder once. That is the part people think matters most. It isn't. What matters most is the moment before all of that, when the witness was still deciding whether this court was just another room Power had rented for the day. That was the true trial, not the verdict, not the sentence. That instant, her hands on the rail, his eyes from the gallery, my question hanging between them. Who warned you? Everything that followed was earned there. So if you ask me what I remember, it is not the applause some reporters wrote about. Courtrooms are not theaters, and justice is not noise. I remember the torn nail on the witness stand, the false license worn from a liar's pocket, the way defense counsel kept asking for mistrial as if collapse itself were a remedy. I remember the school log with Vale's name written by someone who thought a forged signature could outrun a child's tears. I remember Kessler drawing little boxes on a yellow pad while the edges of his world burned inward. And I remember this, most of all, when fear finally spoke, it did not sound brave. It sounded cornered, shaking, late, incomplete. That is still enough for the law if the law has any spine left in it. If you take anything from this case, take that. Courage does not always arrive standing tall. Sometimes it arrives stammering from a witness stand, while every contaminated hand in the room tries to push it back down. The duty of the court is not to admire courage once it appears. The duty is to protect it long enough to finish its sentence. They warned her. She spoke anyway, and once she did, I made certain the next people speaking under oath were the ones who thought threats could hide inside procedure. That is how the case turned. That is how conspiracies crack. And that is why, in my courtroom, when power mistakes restraint for weakness, I let it speak just long enough to identify itself. Then I bring the hammer down.